Okay, good afternoon, members. I call Committee of the Whole Bill 27, Money Judgment Enforcement Act to order. We're on Clause 1. Shall Clause 1 pass? Member.
Mr. Chair, thank you. Just a few more preliminary questions. Was Bill 27 drafted on the basis of an RFL request for legislation?
Minister.
The answer is yes, and I'm told there were many RFLs that got us to stage over time, but yes.
Member for Abbotsford West.
Thanks. The practice in the past has been for the minister responsible to sign off on an RFL. We've already know enough about the history of this piece of legislation for me to suppose that the RFL that has given birth to this piece of legislation may not have been signed off by this minister and this Attorney General, but perhaps she could confirm that.
Correct, this one would have been signed off by the current Premier, former AG.
Member.
And is the minister able to advise the committee as to when that RFL would have been signed off on?
Minister.
Thank you. We found an exact date. It was signed February 26, 2018.
Member.
Thanks, Honorable Chair. The practice with most legislation in the past, and I think from previous conversations with this attorney and others, this has continued, is that prior to a piece of legislation being tabled in the House, it would be examined and reviewed by the Legislative Review Committee, the LRC. Was this bill reviewed by LRC, and if so, when?
Minister.
April 25th, 2023.
Member.
Thanks, Honorable Chair. Am I to understand then that the period between February 26, 2018, when the RFL would have been approved, and April of 2023, that, I guess, roughly, well, 5-year period was consumed with the drafting of the bill? Is that?
Minister.
Yeah, I can confirm that was true.
Member.
Thanks, Honorable Chair. Section 1 is, as is usually the case, dedicated to a whole series of definitions, and there are some that I'd like to review with the attorney insofar as they, not surprisingly, are significant to the body of law, that proposed law that follows. First one, I just want to make sure I am understanding properly some of the terms. An account debtor is defined. I won't read the definition. It's on my copy of the bill. It's page 8. I'm not sure if the page numbers correspond with what the minister has in front of her. So would a bank or credit union qualify as an account debtor? That is, they are presumably holding money to which a judgment debtor is otherwise entitled?
Minister.
Yes, they are captured. The example given by the member of a bank or credit union would be captured under that definition.
Member.
Honorable Chair. Okay, that seems to flow logically. I'll come to sub B of that definition in a moment. But let's just take a second and consider some other examples of an account debtor. Is it anyone, any agency who is obligated to a judgment debtor, and what are examples of that?
Minister.
So the definition is drafted in a broad way to include persons who have some sort of financial obligation and owes money to a party. So that broad definition and the way it's drafted is meant to include a range of things, and I could give you some examples. So an employer, the member, some examples. An employer rent that's owed to a landlord, a contractual obligation that's been, unsatisfied with the consideration, things like that could be included. So it's meant to be very broad, I guess you'd say.
Member.
Thanks, Honorable Chair. And this is significant because it represents a sum of money owing to a judgment debtor that is exigible to a judgment creditor to satisfy the debt that is owed to them. That is the concept as I understand it.
Minister.
That's correct.
Member.
Sub B speaks to a future account. A person who will become obligated to the judgment debtor. There are, I'm sure, numerous examples. One that came to mind, and of course, these are definitions that show up and are applied later in the Act, so I will try to undertake not to repeat my question when the term shows up later. But if the broad concept is as we've just discussed, my question is this. I was trying to think of everyday examples. Let's say you have a renter who is renting a home, an apartment or a house, and they have provided a security deposit, damage deposit to the landlord. That tenant now becomes the subject of a claim. That tenant now, vis-a-vis a third party, becomes a judgment debtor. Is the landlord holding that security deposit, and is that sum of money a future account within the meaning of the definition sub B of account debtor?
Minister.
I just want to thank the member for illustrating that example. I think it is a very practical, everyday example of how this might be used. And yes, that would be, he's correct in the fact that this could be, that example could be determined as a future account, money owing, and captured under this.
Member.
Thanks, Honorable Chair. So just to, not to belabor it, but to follow it through, and I think in creating this new tool, presumably the government is anxious that people avail themselves of it. So to use that example, we have a renter who is paying their rent, but has provided a security deposit, and in today's rental market, that could be a significant amount. It could be measured in thousands of dollars as opposed to hundreds of dollars, given the cost of rent in certain parts of the province. If that person, in a completely separate transaction, they may they become the subject of a lawsuit for the non-payment of something, and a third party secures a judgment against that person, proceeds through the registration process as contemplated in this act. That renter may find themselves in a position where upon departure from their rental accommodations, and they may be expecting to get that several $1,000s back, subject to the residential tenancy provisions. As a judgment debtor, they may discover that that money is no longer available to them, that it has been utilized to, it has been used to satisfy the debt and the debt and the judgment that has been secured against them. Is that I'm trying not to think of fanciful things, but is that an accurate description of how this could work?
Minister.
Okay, so I'll start by saying that, of course, the residential tenancy laws in our province are very broad, and so as a tenant or a landlord, you can avail yourselves of all the potential remedies or processes under there if there's wrongdoing claims or anything associated with that. So we start from that position. But with that being said, the member's right that in the scenario that he described, that is a possible outcome of this legislation.
Member.
Thank you. That's helpful, and I use that example came to mind. But as I was thinking about that example, I thought of all of the other cases now where people are asked to provide a deposit in advance of acquiring a service, and it struck me that in all of those cases, those deposits could well be captured could well be captured by these provisions. And we were talking about an accommodation example, and we're going to talk later about just how efficient the registry is going to be, but it strikes me that someone moving quickly could file the necessary documentation with a hotel, for example, who has received a deposit to hold a room for someone, and technically would be captured, I think, by the provisions. So that broad statement that I've made, any kind of deposit that is being held by a third party on behalf of someone who becomes a judgment debtor, now under the, well, I don't want to say this is new, but under these provisions, that sum becomes exigible to the judgment creditor.
Minister.
Okay, I'll start by saying the goal of this piece of legislation is to make it easier and the tools to be broader, as we'll talk about in lots of detail, I'm sure, for people to collect on money that's owed to them. And the term deposit, I think I just want to make it clear, it's not all deposits that would fit in the definition of reasonably expected to be returned to the person. So for example, the hotel example that the member gave, if the person stays at the hotel, then that deposit is not reasonably expected to be returned to them, right? In the same way that the deposit would be for a residential, long-term residential tenancy. So, and also I think that it's important to say that one of the designs of this legislation, because as the member's raising, there's a lot of intricacies and details about how this will apply in real life scenarios. So as this develops and as we see it showing up, we'll have the ability to exempt certain things under 165 and the regulation powers. So if there are ways that we need to go in and do that, that's a potential way to remedy any things that were unintended.
Member.
Thanks, Honourable Chair. All understood. The reason I'm just taking a moment to focus on this is because I think this has been, this is deliberate, that in creating that additional means or improved means for a judgment creditor to realize on a monetary judgment, the government has turned, the attorney has turned her mind to situations where, although a judgment debtor doesn't have or claims not to have some funds now, there are funds to which they are entitled in the future that a judgment creditor may be aware of, or through the discovery process become aware of. I'll use this example. It wouldn't be the first time that someone decides to, gets into a dispute with a car dealership, for example, and obtains a judgment. Now, car dealerships obtain judgments against clients, but clients get judgments against car dealerships. It strikes me that in a general way, this provision could be used to attach to future lease payments to which that car dealership might be entitled down the road. And now I am getting way ahead. That would require, through the discovery process for the judgment creditor, to garner some understanding of who the leases are with. But it strikes me that in general terms, this could be used in that kind of situation.
Minister,
Yeah, I'm sorry, that's correct.
member.
The next question won't surprise the member, and the minister, sorry, and it will recur a few times during the course of the exchange we have on this bill. The next definition under amount recoverable it sets out obviously the unsatisfied amount of the money judgment. That seems sensible and logical. Taxable court costs to the judgment creditor. Lawyers know and argue about taxable court costs all the time. The one that I wanted to ask at this point wanted to ask the attorney about is the fees associated with the civil enforcement officer and costs incurred by the officer in relation to the enforcement of the judgment. So sub C under that definition. Now the attorney's experienced enough to know that the simple question here is what are those fees? And I'm experienced enough to know that she's going to begin by telling me that they will be set in regulation, and there will be a tariff associated with that. I'm going to ask anyway because I do want to try to determine through this exchange what the rough order of magnitude is going to be with respect to these fees, and we'll pursue that for a few minutes, but I'll ask the general question and then we'll take it from there.
Minister.
Thank you. I'm sure we will dig into this question a little bit more, but we're thinking about it now in terms of how we can determine. So I'll start by saying, yes, the member's right. There will be a tariff and regulation that sets out the fees, but it's based on, it'll be based on work that's already underway. And I'm sure the member knows the court bailiff system and the contracting out that we do right now for enforcement. And so that gives us an idea of the fees that are currently set out and the relative cost of changing that under this regime to the court enforcement officers, but the system will remain the same.
Member.
Okay, thanks, Honorable Chair, and to the attorney. So here's what I think I want to explore a little bit. The bill, and it represents obviously a significant body of legislative work and drafting, is presented, and in her second reading remarks, the minister said this in the accompanying, when it was tabled last spring, in the accompanying press releases and the documents that always accompany the tabling of legislation. The emphasis was on, and these are my words, not the minister's or what was in the release, but kind of a one-stop shop, a single registration, single point of registration, civil enforcement officers who are going to assist people in ways that heretofore has not been available to them. This is going to be a more efficient, a less complicated, therefore presumably less expensive means of people realizing on their money judgments. I'm concerned that the reality may prove to be a little different in all of those areas, but we'll explore that. But as we go through the bill, but what can the minister say today about how this fee schedule is going to be structured? If I have secured a judgment, a small claims judgment in the amount of $2,000 against an individual for damage they may have caused or for improper workmanship on a whatever the judgment is, and I am now I'm seeking to register that and have it enforced. What am I going to be confronted by in terms of fees under this regime? Because much is being made of the fact that there will now be these civil enforcement officers who are going to embark upon work that heretofore individuals have been responsible for. Sounds good. But if on my $2,000 judgment, I'm told you need to post a $1,000 deposit for us to begin our work, then I'm not as impressed, and it's certainly not as helpful from the point of view of a judgment creditor. So the attorney will understand. I'm going to try and zero in a little bit on what this begins to look like at a practical level, and is there an escalating scale? Is there an incremental assessment of costs? It strikes me that a civil enforcement officer may not know what some of the options are until the discovery exercise has taken place. But if the judgment creditor is told right up front, well, you're going to have to give us X, $1,000 on your $2,000 judgment, then we may not be much further ahead.
Minister.
I'd like to thank the member for the question. So it's an important one because the goal of this process is to make sure that no matter the level of debt owed, there's an ability to use the process to get what's owed to you. And so, first of all, the fees would be transparent at the offset. So if you're somebody who has, I'll give the example the member had about a small claims matter, let's say $2,000. You can start by availing yourself of the questionnaire process. So if you're somebody that first of all has already been through the small claims process, which is very low barrier and low cost, and you have, a payment hearing and a schedule and have done all those things to try to collect, you still haven't been able to collect, you go to the court enforcement officer and you say, I'm having this issue. The first step is the questionnaire process, which I'm sure we will go over, which is low cost, low barrier. The questionnaire process will elicit what assets this person might have, the debtor. And in that scenario, the small claims, let's say it's a small claims matter, the person can say and speak with the court enforcement officer to say, okay, well, why don't we go after this asset? And that's going to cost you this much, and it's still proportionate to the claim that you have. So there's an ability to kind of tailor the response based on the level of claim and the person's ability to pursue. And I think that kind of answers the question that was asked about escalation or proportionality, and it's really a conversation between that person and the court enforcement officer that will inform the steps that are taken after the low cost step of the questionnaire.
Member.
Thanks, Honourable Chair. It answers it to a point, and I appreciate that from the attorney. I'm going to push back a little bit on the second or the last part of her answer, and I'll do that. I'll do it using an example not dissimilar from the one I used earlier. And I can't think of a better way to have the conversation than to have it in the abstract doesn't really work. So I think the examples, as long as they are reasonable examples, are hopefully helpful. I'm a single parent. I've been providing daycare services and to a family in my community. They've run up a bill of $4,000 or $5,000, and I'm finally at my wit's end, and I've had to pursue legal remedies to collect that. I now have a judgment. I happen to know that the family has 2 or 3 vehicles, so we know that they have a vehicle that would be outside of any exemptions that, and I say, after registering my money judgment to a civil enforcement officer, look, I know they've got a vehicle that is exigible, and I'd like you to seize it and sell it and get me my money. What's that going to cost? And is it going to, under this regime, going to require that single parent to put up another $3,000 or $4,000? And by the way, I understand that from the point of view of the debtor, there is a risk there as well, because those costs get passed along under amount in this section under the definition amount recoverable. But the barrier would be to that single parent who is told by the civil enforcement officer, look, I'm sorry, but in order to initiate a seizure of that asset, I require upfront X number of thousands of dollars. That single parent says, well, I can't afford that. I don't have the money. I have a rough idea of what the tariff is today for retaining those services, and they are significant. Are we going to see those replicated? Because if we are, notwithstanding what the minister has said about an incremental approach to getting information, there comes a moment when, in many of these cases, the judgment creditor, if she or he is going to realize on the judgment, has to seize an asset. They can't do that themselves, but the the tariff, the cost, the security required today oftentimes places that out of reach. So if, in the example I've given, how much money does that judgment creditor that I've described, that single parent, have to put up to realize on the seizure of an asset to satisfy their judgment?
Minister.
Okay, thank the member again for the important question. Of course, when we move towards setting out the fee structure and schedule for this, fairness and accessibility has to be paramount, and I think he raised a really good example of how we don't want fee structures to be a barrier for somebody to access justice in terms of the money that's owed to them. So that will certainly be something that we think about in terms of setting the fees. But I will also draw the members' attention, which we may get to, section 45D, subsection 2. There's an ability under there to contemplate a written proposal of a fee payment with the enforcement officer. So if that person is in a particular situation with respect to their ability to make a deposit, then they can talk to the enforcement officer, and it's the same. Yeah. Anyway, and they can come up with like a payment structure that works for the person. So it builds in that flexibility based on the case by case basis. And then also importantly, which I think was mentioned already by the member, the costs will come out of the debt that is recovered at the end of the day. Another level of protection.
Member.
Thanks, Honorable Chair. Thank you, and we will get to that. And I noted that when we got to 45, that option. I suppose what I would be urging upon the attorney in creating those regulations, and I'll come back to the general regulations in a moment. I think in order, and this is just my view, but in order for civil enforcement officers to take advantage of that flexibility, it will require direction from the Attorney General. And here's what I mean. I think the tendency will be to be very cautious and proceed in the way that we proceed now. I think what the attorney is suggesting that she would be comfortable with is, in my example, if the judgment for that single parent creditor is $5,000 and she has identified a vehicle that the civil enforcement officer is satisfied is worth in excess of $10,000, that it should in those circumstances be possible for the civil enforcement officer to conclude the agreement and proceed to forfeiture, to seizure, confident that the costs associated with that can be recovered. My humble submission to the attorney is, I don't think without clear direction somewhere that civil enforcement officers are going to do that. So there is the general provision in the legislation that allows for it, but my concern is that that won't be sufficient for enforcement officers to confidently craft the kinds of arrangements that the minister, I think, would be comfortable seeing, and that I would be comfortable seeing. That's a comment. Maybe I'll let the attorney respond, and then I have another question about the regs generally.
Minister.
Yeah, I thank the member for that caution, and I agree that is something that we'll have to watch. But one of the opportunities to do that or set out standards is through the contracts that we would. I think every 3 to 5 years they come up, those contracts with the what will be the enforcement officers, which are now the bailiffs, where you can set expectations about how they enforce and the kind of considerations they should take into account, among other things that we will have to do, because I take that point.
Member.
Thanks, Honorable Chair. We'll come, I think, in, I don't know if it's part 6 or we get to the civil enforcement officers and how that's structured and who they are and the relationship with the Crown. here's my general question. We come up against this time and time again with respect to not just legislation amending existing legislation. We've seen some examples of that, but new pieces of legislation and new initiatives. The attorney fairly pointed out that a lot of work has already taken place around the question of fee structure. And I say this not in some sort of mischievous way. I don't think we're going to get through the whole bill today, so we're likely to be back at it for a bit when we come back after next week. Is that work far enough advanced to, and I expect it is, to at least release a draft of what that fee schedule might look like? Of course, I'd like to see amounts, but even the structure of it would be helpful to see at this point to address that question of incremental fees through the exercise. The opposition's sort of seize on the vacuum of information to speculate, and generally speculate in ways that reflect negatively on governments. But if the work is far enough advanced to at least present at some point next week some indication of what this looks like, then we're not having the conversation in a vacuum, and attempts I might make to raise the boogeyman of excessive fees disappear.
Minister.
So to the member's point, the normal course of things as legislation works through this House is we don't instruct our team to work on regulations until after the legislation is received, royal assent, or is at least passed. So no, there's nothing to show at this stage when it comes to the fee structures. But I will say again is that I think the principles that the member raised, but also that we are keeping in mind, is fairness and accessibility and access to justice, which is what is guiding the work of this piece of legislation. So the points that he raised with respect to making sure that a lens is being applied to that will be part of the goal when developing the regulations.
Member.
Thanks. I'll just one more gentle kick at this, and I have the attorney's answer. Here's my other recollection, though, of how these things flow through the development of legislation, and there's this beast called Treasury Board, to which the Attorney General is, as all her colleagues are answerable to, and they ask these questions like, how much is this going to cost, and how much of that will be realized from the collection of fees. And I am certain that somewhere in one of those big binders over there is an estimate that has been prepared for the Treasury Board to either disclose the fact that this is going to require an influx of additional dollars, or that the ministry believes the fees collected will be equivalent to and or cover the cost associated with these changes. So I'm not trying to be argumentative, but I'm not fully accepting of the proposition that there's been no attention turned to the dollars, because I rather suspect that the minister has been required to assure Treasury Board, or inform Treasury Board, of what the implications of this are and how much revenue will be recovered via fees.
Minister.
Thank you. I have no further information to provide the member in terms of the specific costs. I think he's trying to analyze how much costs will be borne by the creditor when they enter the process, which is not the level of discussion that we've had with Treasury Board at this time, but we will, and obviously that going forward will be something that we'll have to discuss and work on when we get to the regulations, but I have no new information on that. Other
Member.
Thanks, Honorable Chair. I'll just try this then. Has the Attorney General's Ministry prepared a summary for Treasury Board estimating what the fee recovery amount will be under this regime?
No,
Minister.
no.
Member.
Okay, I'm surprised about that because that may lead to some unpleasant surprises down the road and interesting conversations between Treasury Board and the Ministry. But if that's the answer, then that's the answer that the attorney has offered. I'm going to further down the same page. There's a definition. I should say, in other contexts, we may come back to some conversations around specific fees, but I'll leave the general conversation for the moment. Further down the page, there's a defined term, deposit account. Again, I'm not going to read the definition, but sub A refers to accounts, money accounts. Just above that, it seems to be a definition that captures or is intended to capture the general kinds of bank accounts that people and companies and agencies would have at their financial institution. Am I correct in that assumption?
Minister.
Yes.
Sub A, is that a definition, is that intended to capture what we might otherwise refer to as things like term deposits?
Minister.
Yes.
Member.
Thanks, Honorable Chair. So that's interesting. Again, and I'll state this, these definitions are important because they speak to what is exigible for the judgment creditor as we trace the application of these terms through the legislation. That's why they have relevance. So subject to all of the other provisions of the Act, the general provision here is that as a judgment creditor, I might be able to attach to these deposit accounts as a way of satisfying my money judgment. But flowing from what we just determined, so I can, if the attorney sues me and gets a judgment against me, she can attach to she can register and she can attach to my savings account, my checking account, and all. But if I have a sizable term deposit in the same lending institution, the definition doesn't capture that. And maybe that's because there are other ways for her to attach to that asset. But I'm not sure I understand why the distinction in this case, in the definition at least.
Minister.
So the member was correct in saying that there is another part of the piece of legislation that would cover what he's referring to, and that would be under Part 8, Division 4, securities, security entitlements and future contracts.
Member.
And those are the same provisions, presumably, that would cover things like an RRSP.
Minister.
RRSPs are exempt under this legislation.
Member.
Thanks, Honorable Chair. This is where the challenge in dealing with the definitions is I want to be a bit structured so we don't recover ground, but that's worth at least one follow-up question. RRSPs are exempt in their entirety or subject to an exemption that we will come to later?
Minister.
So the question is dealt with in Part 13, Section 164, subsection 2 and 3. So generally speaking, yes, RRSPs are exempt, but they're under subsection 3 are, I guess, exceptions to that are listed out in the legislation.
Member.
Still with the deposit account defined term, sub B sets out a description of a type of account that is not captured, a second type of account that is not captured by the term deposit account, an account under which a person is obligated to pay a judgment debt or a specified sum of money with or without interest at a specified date in the future. On the surface, that sounds a lot like a term deposit, but there's clearly an intention to for there to be a distinction or to capture something else. So two questions, if I can, for the purpose of time. What's an example of that kind of an account? And again, what's the rationale? What's the rationale for not including it in the definition of deposit account?
Minister.
Okay, so I think it helps to explain this definition by understanding the purpose for its use in the legislation. So I'll start with that. So the goal behind having a definition for deposit account was to separate it in terms of the ability to have a single seizure of whatever's owed from that account. And the reasons are really, one is practicality. So we would assume deposit accounts have a mix of funds that are flowing into it, whether it's some may be exempt, right, from seizure and some might not be. So if a bank or institution is kind of like blindly seizing, then it would potentially create confusion over what was exempt and what wasn't. So there's like a practical reason for singling out deposit accounts in this section. And then the subsection B is meant to ensure that future accounts are also part of that exclusion.
Member.
Thanks, Honorable Chair, and thank you to the attorney. So, again, taking the bill in its entirety, and it was helpful to hear what the attorney had to say. But can I ask this then? Is there does an obligation, in the way that the attorney has described this, is there an obligation that falls to the institution at which the deposit account is located now to determine source of funds for an account? Because I thought I heard the attorney talk about how a savings account, can be comprised of funds from a variety of sources, some of which might be exempt. I'm not disputing that, but I thought the objective here was to instill in the hands of the judgment creditor the right, once registered, to, if the decision has been made by the judgment debtor to deposit that money into an account, to give the creditor access to the funds in that account. It sounds like the institution and or the creditor now have to, and the enforcement officer now have to engage in some kind of a determination of where the source of those deposit funds come from. That's going to get awfully complicated.
Minister.
So I'll start with the clarity that nothing in this legislation puts an obligation on the bank or the financial institution to adjudicate whether it's exempt or non-exempt in terms of what's in that deposit account. Really, the goal of this definition and how it's used is to minimize the type of problems that the member raised in terms of exempt and non-exempt. So the way it's structured is it will require the enforcement officer to give a notice of seizure in a deposit account for only if they have a good faith belief that there's non-exempt funds in that account. And it's not a standing seizure, it only happens once. So every time they would have to do a new one to step into the account. So you can see in that process, it'll minimize the confusion that may have if a deposit account is mixing with exempt and non-exempt funds at all times. And it also gives the person that's subject to that seizure the ability to provide evidence to come forward because it has to be renewed every time, right? To say, actually, I'm using that account for exempt purposes. So it's actually meant to minimize the conflict there.
Member.
Thanks, Honourable Chair. Again, we'll undoubtedly come to this further along, but for reasons the attorney has just alluded to, this notion that what is being created here is a single registration, one registration, one act play that ultimately leads to collection for reasons the attorney has already begun to allude to isn't quite true. There are in some cases multiple registrations that are still necessary. I'll let the attorney respond to that, but cognizant of the time, I'll ask my question and ask her as well. The only part of what she said that I'm still, or maybe didn't say that I'm still confused about is what sub B is designed, what kind of account and why is it deemed necessary to exclude that from the general definition of deposit account and what it's intended to capture and why?
Attorney General.
So rather than a specific example under that subsection B, what I can say is that the drafting consideration there was to make it very clear that future accounts are exempt. So that is just a term of clarity that the legislative drafters wanted to ensure was in there in the event that comes up in the future, although I can't give it a specific example of the type of account.
Member from Abbotsford West.
Thanks, Honourable Chair. The attorney indicated those accounts are exempt. Did she mean those accounts aren't captured by the definition of deposit account, or they are exempt from seizure or attachment?
Attorney General.
Thanks for that clarity. It under the definition of deposit account is what I was referring to, not the general exemptions.
Member for Abbotsford West.
Honourable Chair, thank you. Just before we move on to the next page and some of the few of the definitions there, I neglected to offer the attorney an opportunity to put something on the record that I think is important and something she alluded to, but we sort of passed over. I'm going now back to the definition of amount recoverable, and I think this is important that the attorney be able to put on the record that if she agrees with what I'm about to say, The legislation is very much intended to operate so that in circumstances where a judgment creditor becomes obliged to pursue enforcement remedies to collect on their judgment, the costs associated with doing that could escalate significantly and will ultimately be imposed on the judgment debtor. So that a judgment debtor who chooses to ignore a $2,000 debt, and I am making up numbers now, but could find themselves in the right set of circumstances paying not $2,000, but $3,000 or $3,500. And I think it's worth having the attorney make clear that that won't happen by accident. That is what this legislation is intended to do. It is intended to pass along the costs of enforcement to people who do not pay on the debt they have been adjudicated to owe.
Attorney General.
Yeah, thank the member for the question. It is correct that it's not a change in policy in this legislation, but it is correct that the pressure on the debtor is to pay quicker and pay their debt owed, because costs will escalate if they don't, right? The cost of recovery is their burden to bear. So if they are able to come up with a payment agreement earlier on, avoid the kind of costs of enforcement orders, and obviously it's better for them in terms of settling their debts. And so it is one of the principles of the collection system, and it currently is under the policy like that. Yeah. It's a continuation of policy.
Member for Abbotsford West.
Thanks, Honourable Chair. Only because the attorney mentioned it, and it's maybe worth closing the loop on this. So in my example of the $2,000 debt, the option for the debtor exists to enter into a repayment agreement that doesn't necessarily involve payment of the full amount at first instance, but payment over time. The attorney can confirm that, and also confirm who is obligated to sign off on that agreement. Is it purely an adjudicator, a civil enforcement officer, or the judgment creditor, or all three?
Attorney General.
Okay, thank you. So the system that we're putting in place through this bill is all voluntary. And the goal is to give better tools in order to get to a resolution as fast as possible and get the payment that's owed. So there are many scenarios that will flow through the system. One will be a creditor may choose not to register, right? They may choose not to go forward and register because they've received payment. They may, and they hopefully should register if there's because it protects them in the ways that the Act sets out. Or they can, at different points, after having come up with an agreement, and that would be a sign-off between the debtor and the creditor, right? If they've come to a payment agreement, then they can change their position with respect to anything in this, any of their enforcement positions or the things that they're pursuing based on that agreement. So it's going to be, I guess, fluid depending on the scenario and their ability, but there's no direct sign-off as per se that the member raised in terms of the enforcement officer or besides maybe an agreement between the debtor and creditor.
Member for Abbotsford West.
Thanks, Honourable Chair. So to be clear, as we move through these provisions, what I'm hearing from the attorney is a judgment creditor who registers can't be put in a, once they've registered, can't be put in a position where a payment schedule is imposed upon them by the civil enforcement officer. They would have to agree to it, although I still think from my reading, the Act contemplates a payment schedule ordered by the courts. And that is still contemplated, but except for a payment schedule ordered by the courts, a judgment creditor would have to agree to a payment schedule that didn't involve payment of the full amount.
Attorney General.
Okay, thank you. So there is no power for the enforcement officer to impose a payment schedule on the creditor. The way it would be structured is the creditor registers, says to the enforcement officer, look, I need help collecting this. They have the ability then to instruct the enforcement officer on the collection, so that's one way of them driving it. But in the instance where they have instructed the enforcement officer to do certain things, like take assets, there may be in there the enforcement officer establishing a payment structure or recovery structure of that asset, depending on what it is, that maybe the creditor wouldn't have a direct control over. So it's not as direct as the member suggested in terms of a enforcement, but there could be contemplated something where there is a payment structure that the enforcement officer does have or set out with the parties. And on top of that, throughout all of this, there may be a scenario ongoing, and we think, hopefully likely, that the starting of the structures of this process will force parties to come to an agreement, because it's less pain for the debtor to, if they're able to comply and come up with an agreement directly with the creditor outside of this process than it is to escalate. So that is kind of an ongoing thing that the agreement might, a payment structure agreement might happen between the parties.
Member for Abbotsford West.
Thanks, Honourable Chair. To the attorney's point, there is nothing in this legislation that I have seen that precludes or diminishes the capacity of the civil resolution, dispute resolution tribunal, or the small claims court, or any court for that matter, at the conclusion of a process, of a trial, where the determination has been made that X owes Y a certain amount of money, to facilitate or make an order that amount will be paid as follows over a certain period of time. So payment schedules as ordered by tribunals, and in the context of small claims and civil dispute resolution, that has historically been quite common, where the debtor, the now judgment debtor, throws their hands up and say, okay, I've lost, but I don't have the $3,000, and the trier of fact says, all right, well, but you're going to have $800 a month, or whatever it is. Those processes can continue, and in that context, it would be the judgment creditor would only have access to this mechanism, as I understand it, were the debtor to be in default of that payment schedule.
Attorney General.
That's correct. The member clearly articulated the existing legal processes that anybody can avail themselves through the various dispute resolution processes that we have, that may mean that there's a court-ordered payment structure that, yes, it's if in breach, then you can rely on the sections in this piece of legislation to get recovery of that.
Member for Abbotsford West.
It is, Madam Chair, a unique feature of legislative drafting that sometimes terms that we think have a common and straightforward meaning need to be defined in a certain way. I'm looking now at the definition of due, and its reference to a monetary obligation, meaning any of the following, and the two that captured my attention, mostly because I didn't understand them, was sub A, that the obligation is owed unconditionally, even if it may not be payable. And on the surface, you got an unconditional, an obligation that's owed unconditionally but not payable, and I'm trying to think what that is intended to capture.
Attorney General.
Okay. This section, as the definition was put in place, maybe we'll start there, is to contemplate times where you need a notice of seizure has happened, but the amount has not been received yet, so it's not payable. So it's something that, say you've contracted out your services, and at some point when you're done, you're going to get paid for those services you did. What this definition does and how it's used in the Act is to make clear that once that money is received by you as the debtor, it can be seized by the creditor. So if it's an amount that's unconditionally, owned unconditionally, even if it may not be payable. Payable meaning like at that point in time, it's not in your hand. You haven't. It's a future payment that you're receiving. If that makes sense.
Member for Abbotsford West.
I actually thank you. I understood all of that, but just want to cross-check this, the relevance of what the minister has just said, and significance in the context of this legislation. If I'm correct, is that those funds in the hands of the third party are exigible. Long before, or before, I shouldn't say long before it goes to the debtor. If the funds fall within this definition, they are exigible.
Attorney General.
Okay, so yes, that is the reason that the term in there is payable and not paid in the definition. So it potentially could go straight from the third party to the creditor.
Member for Abbotsford West.
Thank you. And then in a similar vein, sub C, well, it's the same question. I was unable to determine on my own the circumstances that this might apply to within the context of the defined term due.
Attorney General.
Okay, so this definition was drafted out of, I think, appropriate level of caution to make sure that we're covering off all the scenarios that might fall in the event of a third party payment owed to the debtor that should be given to the creditor for satisfaction of what is owed to them. So under this subsection, I can do it by example. Let's say you are a debtor and you set up a contract, you contract out your services, and when your services are done, normally you would be paid for those services. It's meant to avoid the drafting of contracts to stall payment or to avoid payment directly after the conditions are served, to avoid having to pay back the creditor what's owed. So what it does is it triggers the ability of the creditor to go after the third party once the conditions are established or met to be paid. So I've done my contracted work. I've painted your house, for example. So under a contract that I had with you for me to paint your house, the condition is I paint your house, you pay me, right? And so once the condition of painting the house is done, then it gives the more breadth of the creditor then to go after that payment directly from the third party and avoids any unnecessary avoidance that might happen by the debtor to avoid payment or that money going to the creditor, delaying or anything like that.
Thanks, Honorable Chair, and that's helpful. Let's go to, I guess, the next definition, which is significant for all kinds of reasons, and that is employment remuneration. I'm going to ask this question to start the conversation. Am I correct in suggesting to the committee that, subject to the exemptions that are laid out later in the legislation, certain amounts of employment remuneration are intended to be exigible to a judgment creditor?
Attorney General.
Yes.
That being the case,
Oh, you got ahead of me there for a second. Okay, member for Abbotsford West.
Can't imagine that ever happening.
Won't let you.
That being the case, the definition of what is captured by employment remuneration becomes important. The language here I thought was interesting. Employment remuneration in relation to a judgment debtor means the total of, and the first thing here is an amount of money due to the judgment debtor under a contract of employment. So there's a couple of things that come to mind. When I read that on the surface, I immediately thought of someone who has, contracted for services, but then I realized, and if you are part of a collective agreement, you have a contract, you have a contract for service. But a lot of people in this province and in this country who get hired on wouldn't have a contract per se. They would be paid for their services, and they might have they may have an understanding, and the boss has told them they're going to be hired for X amount per dollars, but they don't have a contract per se. Anyway, I think that the attorney gets my point. Is this intended, is sub A intended to cover everyone that qualifies as an employee, for example, under the terms of the Income Tax Act, or is there a differentiation? And if that is so, then what is the significance of that, if any, of that language, amount of money due to the judgment debtor under a contract of employment?
Attorney General?
So the capture, the definition of contract, I guess, would be contract in the sense of any form of legal contract, oral or written. So it's true that there may not be a written contract, but certainly by the behavior of the parties, there's an oral contract to do. So it's meant to be broad in terms of the sense of that word.
Member for Abbotsford West.
Thanks, Honourable Chair. I don't, I rarely would venture into arguing with the skilled people that do the legislative drafting. And the attorney's answer is helpful. My immediate reaction is the language is problematic. I would have thought that if that's the intention, and I accept that it is, to capture within the definition everyone that works for someone as an employee, then stipulating that the contract may be an implied contract as opposed to a formal instrument that can be pointed to. I can think of so many examples where, especially today, the relationship between employee and employer is so short term that you might have difficulty as a judgment creditor making an argument that there is a contract of employment, except that there is money owing because someone worked. So it's helpful to know what the intention, the attorney's and the government's intention is, but I wonder if the attorney shares any of the concerns I do about the decision to use that phrase and that language, and whether the argument might be made down the road that in certain cases that definition doesn't cover certain types of employees.
Attorney General.
Okay, so in the nature of our, the way we draft our legislative drafting decisions, the term contract, as it's used in this statute, is used in other pieces of legislation like the Employment Standards Act to meet the same definition of the broadest sense of the contract. So although I appreciate the member raising the concern, I think the legislative drafters had considered the use of that term and how it was used and relied on how it's used in other pieces of legislation to do that. And also, just as an aside that's linked to this, it's more in the debtor's interest from their perspective to be found to be under an employment contract, because in that sense they may be eligible for exemptions, whereas if it is the employer that's an account debtor, without that, then they can't avail themselves from the same exemptions.
Abbotsford West.
Thanks, Honourable Chair, and to the attorney, and she has zeroed in on what I think is the relevance. If I'm a judgment creditor confronted by a judgment debtor who is trying to avail themselves of the exemptions that flow from being an employee and wage remuneration, I might want to seize upon language to say, no, that person isn't an employee within the meaning of the Act. I accept, as I say, that the language chosen was deliberate. I think I heard the attorney and her able staff discuss and reference the Employment Standards Act, and the use of that term in the Employment Standards Act is undoubtedly relevant. In this context, however, I will merely say, and the attorney can respond or not, that reference to a debtor under terms of employment or in an employee relationship as might alleviate any confusion, and we'll see if it at what point, if any, it becomes an issue. If the minister has any thoughts on that, I'm happy to hear them. I'll go straight to my next question, though, and it relates to sub B of that definition and the reference to fair market value of goods and services that the judgment debtor is entitled to receive under a contract of employment referred to in paragraph A. And I, again, was trying to think of an example that would have required the differentiation that the drafters thought necessary in distinguishing sub B from sub A.
Attorney General.
The subsection B is meant to bring clarity to other forms of compensation that may not be money. So, for example, if there is a judgment debtor that owes money, they can't tell their employer, well, give me a gym membership, let me use the car, use other things, pay me in other ways besides money, so I won't have it seized because of this amount I owe. So it helps to capture that broader sense of compensation for work.
Member for Abbotsford West.
Thanks, Honourable Chair. Well, that's a good transition from there. I'm going to flip the page over to page 10 in the next term. I had a brief interest in future account. And again, I was thinking of examples from the point of view of what might be exigible by a judgment creditor, and how these things change over time. And the example I wanted to quickly pursue with the attorney is whether under this definition or some other definition provision of the bill before us, might a judgment creditor attach to reward miles, which today, as opposed to a decade or two ago, can be of significant value, whether they relate to travel or purchase. But some people have accumulated sizable reservoirs of wealth in the context of reward miles that have a future value if redeemed, or when redeemed, but sit there. Is that is something like that captured by the definition of future account, or captured anywhere else in the Act?
Attorney General.
Okay, thank you for that very provocative question. We have an answer for you. It would not be under the current definition that the member suggested, a future account, but the air miles example wouldn't be under account debtor, because it's not a monetary obligation, but it would be under property. So it would be determined under this legislation as property under section 67. It gives the chief, or the enforcement officer, broad power to seize the property of the debtor. And that would be, and then under section 43(1)(a), it gives the enforcement officer the power to do what it deems appropriate with that property once it's classified as property. So those are the two powers that I think come into play with the example that the member provided with respect to air miles.
Member for Abbotsford West.
Thanks, that's helpful. So the conclusion one is able to draw from the attorney's response is that under this legislative regime, the civil enforcement officer, in consultation with the judgment creditor, would have as an option the attachment to an account of what do we call them? We use the trade name air miles, but that's not fair. But they are loyalty programs, I guess, is what they're called. And I heard the attorney talk about the fact that sometimes they have cash value. They certainly have redemptive value. So this legislative package contemplates the possibility of those loyalty accounts being attached by a judgment creditor via the civil enforcement officer. I think the attorney will confirm that. And I guess the other thing that bears saying is that is true under this regime. It is probably also true today. The alteration is the introduction of the civil enforcement officer, unless the attorney is going to suggest that substantively this now has creates that option. The option probably exists today to attach to that asset, if I can use that term, or that property. What we're trying to do is make it easier and provide a new instrument for doing so. But that is a question, not a statement.
Attorney General.
Thank you. So this legislation does change what is the status quo at this point. So it starts with, in the current process, let's say in the writ there was something about air miles, right? But that would be the person knowing that that was something the person had. Then in our view, the court bailiff wouldn't have the same tools that they would have under this legislation, and an enforcement officer to not only capture the property under 43-1, but also take actions, specific actions against that air miles company or wherever they're held, to do things to recover. So it not only makes it easier, as the member suggested, and the intent is to have more possibility, it also gives more powers to the enforcement officer to take steps to, I guess, go after a broad range of property.
Member for Abbotsford West.
Thanks, Honourable Chair. Again, that's helpful. What I heard the Attorney General say is that today, perhaps, these loyalty program accounts that many of us have and that have value, have redeemable value, are either not exigible or it is very difficult to attach and seize them. And now it's an example I've offered up only because I think it has daily relevance in many of our lives. She also seems to be saying to the committee that she believes the provisions of the legislation in their totality will assist in making that particular type of asset far more exigible to a judgment creditor. And if I have that right, I'm interested to hear the attorney say that.
Attorney General.
Yeah, I think you captured what I was saying.
Member for Abbotsford West.
Honourable Chair, the next definition I just wanted to spend a moment on is the term goods, which appears actually ironically right below future account. And there are two aspects. Again, I'm not going to read the definition, but in the context of the definition, the term investment property appears. And if we think about that in the context of everyday discussion, it evokes a certain understanding. I don't think that's necessarily what is meant. A piece of property that someone holds that is not a primary residence, but maybe it is. But I wonder if the attorney could clarify what she and the drafters mean by the term investment property within the definition of goods. And by the way, does not include, it's the exemption again, goods meaning tangible personal property, fixtures, crops, but does not include investment property. So what aren't we including there?
Attorney General.
Okay, so I'll start by giving clarity that investment property, as in this definition, does not mean real estate, and the definition is pulled from the Personal Property Securities Act, and in terms of goods, and in that act, investment property is defined, and I can read it. It's security, whether certified or uncertified, security entitlement, securities account, future contracts, and future account.
Member for Abbotsford West.
Thanks, Honourable Chair. And my recollection is that this legislation imports the definition of the Personal Property Security Act, except in circumstances where specific definitions are set out. I may have said that incorrectly. My understanding is that this legislation adopts the definitions contained within the Personal Property Securities Act, except in circumstances where that is expressly said not to be the case. Is that correct?
In section 2.
Attorney General.
Oh, sorry. Sorry, Chair.
Member for Abbotsford West.
Thanks, Honourable Chair. The other term from the definition of goods that I, and it is again, the term, it is listed there as not being included in the definition of goods. The phrase goes as follows: trees other than crops until the trees are severed. I should ask, is that a definition that flows from the Personal Property Securities Act as well? Clearly, in the presence of the forestry minister, we would acknowledge that trees, whether they are harvested or not, have great value, but they are not included here in the definition of goods. And is that consistent with the existing provisions of the Personal Property Securities Act?
Attorney General.
Okay, so the entire definition of goods is directly from the PPSA, so that includes the particular portion of the definition that the member is talking about. The reason behind that is at the stage that a tree is alive and growing, it's considered part of the land that it grows on until it's severed, which is the reason for that definition.
Member for Abbotsford West.
Madam Chair, in 2 days, I'm going to qualify for 30% off at Denny's. That's the good news. Just one, and I got it last year. But that has increased the frequency with which I have to visit certain rooms in this building. So I wonder if we've
Calling a 10-minute recess. Okay, folks, we're back to Bill 27, Money Judgment Enforcement Act. And a big surprise for all of you, we are on Clause 1. And back to the member from Abbotsford West.
Thanks, Honourable Chair. Still with the definitions, there's a short definition of the term interest, which shows up, not surprisingly, frequently through the provisions of the Act. And the definition specifically applies to interest in relation to property, includes a contingent or equitable interest in property. So here's my question, and again, I'll ask it in the context of an example, and I won't profess to remember thoroughly or be an expert in the laws of equity and how they may apply today to interest in land, but the presence of the word here confirms that it is at least relevant. So let's take a case where a couple has married couple, common law couple has parted company, has separated, and the matrimonial home, which was the principal residence for both individuals, was registered in the name of the husband. The wife, the separated wife, has, we know, either an equitable interest or in some instances a statutory interest in that property. But it's no longer her principal residence. For unrelated reasons, she finds herself on the debtor's end of a judgment. Is her equitable interest in what was formerly her principal residence, but is no longer her principal residence, is that now exigible to a judgment creditor who is seeking to enforce a money judgment against her?
Attorney General.
So in the scenario discussed by the member, the equitable interest in that property, yes, it would be exigible under this piece of legislation, and because it's not the person's in the hypothetical scenario's primary residence, then they wouldn't be able to avail themselves of any of the protections offered potentially for primary residence.
Member for Abbotsford West.
Thanks, Honourable Chair. Okay, that is helpful in terms of the answer. Is the, and again, I'm trying to use examples that I think are not fanciful, but may reveal themselves to be practical and real. And so in a situation where a relationship breaks down, it is still not uncommon that one of the spouses doesn't appear on title. When a relationship and separation occurs, it is also not unusual that financial circumstances tighten and bills get left unpaid. Some of them are joint debts. Frequently they're joint debts, but judgment is taken against both parties who, in the case, for example, well, in many cases, have signed on and are jointly and severally liable for the debt. So we're now in a situation where the protection that might otherwise exist for that spouse with the unregistered interest in what was the matrimonial home disappears insofar as a judgment creditor is concerned. Is that the intention, and is the attorney comfortable with that fact?
Attorney General.
Okay, so the resolution to this matter would start with the Family Law Act and all the provisions of that would apply first and foremost in terms of division of property, settling of debts, and payment to any potential debtors through that separation process. So the likelihood of that resolving the matter is high, but in the instance that there are lingering debtors to any individual properties, if the family is no longer, or the parties are no longer living in the home, then yes, it is subject to a debtor, a creditor's claim against that property. And the purpose of that is really to do two things. So if we wouldn't want somebody to unnecessarily have to leave a place that they were living in, right? So if they're living in the primary, it protects that kind of housing that person has. But in the instance where they're no longer, then it should be treated the same way as any other property that could be collected upon.
Member.
Thanks, Honourable Chair, and welcome to the Chair. Again, that's helpful. And by the way, I can think of a myriad of other circumstances where someone might have an equitable interest where notions of matrimonial law don't apply. There's certainly, and my guess is that's what this provision is designed to address, is those circumstances in business and elsewhere where people have an unregistered equitable interest, and the objective is to ensure that a judgment debtor who does have an equitable interest in property, that interest is exigible and attachable by a creditor. I presume that is the objective here.
Attorney General.
Yes.
Member.
Let's go down to, Madam Chair, the definition of judgment debtor. Obviously, a person, a significant player in the whole equation of enforcing money judgments. So, a person other than the government, and I presume that is a reference to the government of British Columbia or the government of Canada, who is required to pay money under a money judgment. I realize there is a whole body of legislation around Crown proceedings, but it is, in the instances where something like this comes before the House and comes before a committee, it is, I think, always worthwhile and appropriate to ask whoever happens to be the Attorney General at the time why it is that a certain set of rules should apply to everyone in the province, everyone in the country, except for the government. Meaning, if the attorney gets a judgment against me, I am, as judgment debtor, subject to all of these provisions. If she gets a judgment against my colleague from Terrace, there's a whole, in Kitimat, a whole set of, he is subjected to a whole, all of these provisions. But if she gets a judgment against the government of British Columbia, none of those provisions apply. Why is that?
Attorney General.
Okay, thanks for the question. So the government is situated quite differently than private owners of property under this, quite rightly so, raised by the member. And first and foremost, there's a whole series of, as he mentioned, other laws and rules that apply to government when it comes to debt. And one would be the Crown Proceeding Act, which Section 13, which requires the Minister of Finance to pay any amount that is owed by government to individuals. Government is obviously it's public assets that governments have, so they're presumed in that sense to be solvent and always able to pay debts, which is a different circumstance sometimes with individuals. And there's a whole regime of legislation related to the sale of public assets and how that plays out. So there are different powers there.
Member.
Thanks, Honourable Chair.
Thanks, Honourable Chair. I can sue the government of British Columbia, I can sue the Crown and the right of the government of Canada, and I can, in certain circumstances, and I can, with difficulty, obtain, if I am correct, and the court orders such, I can obtain a judgment against them. But neither the government of British Columbia nor the government of Canada is a judgment debtor within the meaning of this legislation. Is a municipality capable of being a judgment debtor? I can sue a municipality, and I believe there are references elsewhere in the legislation to municipalities. And when I say municipalities under the community charter, I'll include the cities of Vancouver and Victoria, which have their own governing legislation.
Attorney General.
So yes, a judgment debtor could include a municipality. So the member is correct about that.
Member.
Can a regional government be a judgment debtor?
Attorney General.
Okay, so the definition of person is the key one in this one. So if the body, whether incorporated or in statute, is deemed a person, legally speaking, then they will be captured by this, except for the government of Canada and the province. So the question whether or not a regional district is a person is something that we will get back to the member on.
Member.
And in the same vein, Madam Chair, First Nations government, is a First Nations government capable of being a judgment debtor within the meaning of this act?
Attorney General.
So the answer to that question would be very complicated depending on the nation and whether or not they have an incorporated body that they're doing business under that would be considered a person. So I think it would just depend on the legal analysis related to that particular debtor and their situation and whether they fit the definition of person.
Member.
Thanks, Honourable Chair. I'll just explore that for a moment because happily First Nations across British Columbia have become more and more engaged in the economic life. Still got a long ways to go collectively, but that is, I think, the progress that's been made has been good. So what is it? I don't think it's a fanciful line of questioning. With more and more contractual arrangements arising between First Nations and contracting parties, service suppliers, and it strikes me that where there is a dispute, those parties whom wish to pursue an action would like to know what remedies are available to them. So I won't ask the attorney to summarize 30 years of jurisprudence, but presumably there are some principles and common features that will determine whether or not if I am contracting with a First Nation, it will generally be a corporation of some sort set up on behalf and controlled by the First Nation. Whether that First Nation is capable, for the purposes of collecting on a money judgment, capable of being considered, or would be considered, a judgment debtor in circumstances where the court rules that is so.
Attorney General.
Okay, so in the scenario that the member provided where it is an incorporated body that's doing business, then that would be captured under the definition of judgment debtor. If it's a government, then the area of law becomes very, very complicated, and it would depend on that scenario, yeah.
Member.
Thanks. Okay, last kick at that in terms of a contract with a First Nations government that is not incorporated, and the contracting party is not a corporation, and a judgment has been obtained against the First Nation government. What, broadly speaking, would determine whether or not the provisions of this Act apply insofar as they become a judgment debtor? What would the considerations be?
Attorney General.
So the answer to this question is embedded in the history of colonization and legislation with Indigenous people over time. It starts with the Indian Act, which is very paternalistic in the sense of the powers that are given to governments and their ability to do things. And then all the way up to modern treaties, which you could imagine are different with each modern treaty that would give different powers and contemplate the questions asked differently. And also the many First Nations that have economic development wings and powers with their corporations and the work that they're doing. So I will just say that it is a complicated and factually driven question that I wouldn't be able to answer in the absence of a specific example, given the layers of laws and history and treaties that are involved in that and the nature of the debt.
Member.
Thanks, Honorable Chair. I guess the obvious question then, just to wrap up with this section, and I'm not in any way underestimating the legal complications associated with answering the question around answering the questions I've raised. Is this part of the legislation then that would have been reviewed with either the Leadership Council or First Nations representatives, which I understand is now sort of part and parcel of the development of legislation? Maybe the attorney can just put on the record the nature of the discussions that took place, particularly with reference to the creditor's remedies that and how they might apply in the circumstances that we've discussed.
Attorney General.
So as per our process, this was before the interim approach, but as per our process, we notified FNLC, the Métis, the Alliance, and treaty nations about the development of this piece of legislation and the work that we're doing. We didn't receive any feedback.
Member.
Thanks, Honorable Chair. Last question on this. At what point in the exercise does that notice go out? Is it post RFL, pre LRC, post request for legislation, pre legislative review committee, or does it come at the end after the legislative review committee has examined it?
Attorney General.
So after the RFL, the FNLC Treaty Nations and Métis were notified of the development. And then when we had closer to, like we were at a draft legislation stage, there was an offer given to, as I mentioned before, all of them to see if they wanted to look at the draft or give feedback under an NDA. And we didn't, nobody took us up on that offer.
Member.
Thanks, Honorable Chair. Let's go down to the term money judgment, still on page 11. And so sub A of that definition, I think, is pretty straightforward in terms of where a money judgment can derive from in terms of the courts, the courts here in British Columbia and the Supreme Court and Federal Court in Canada. Sub B talks about an instrument under an enactment as if it were an order or judgment of a court. Are we talking here about tribunals and civil resolution tribunals? What gets captured by that definition in terms of alternate dispute resolution and other bodies that may have the authority to make an order for the payment of money, WorkSafe, for example?
Yeah, it's meant to include tribunals or certificates issued under administrative decision makers.
Member.
Would include the residential tenancy branch?
Attorney General.
Yes.
Member.
WorkSafe. Thank you, Madam Chair. WorkSafe, that's a question. Civil dispute resolution tribunal, that's a second question.
Attorney General.
Yes to both of them.
Member.
Is there any significance or magic in the use of the term, and it's as is always the case with the very precise and capable drafters, sub A refers to orders of the court, sub B refers to an instrument. Most of these tribunals would, I think, believe that they are issuing an order. Is the term instrument meant to capture something broader than the orders that these tribunals make?
Attorney General.
Yeah, it's meant to capture things like certificates issued by administrative decision makers, so that's broader than that.
Member.
I'm looking at further down in that same sub C and sub D, again, includes exceptions that are not captured by the definition in sub A and sub B. A prescribed class or type of order or judgment referred to in paragraph A. So I take it what we're trying to do there is say all of these court orders from all of these courts represent money judgments, but the government wishes to reserve the opportunity by regulation to say certain court orders aren't captured. If I got certain orders of the courts listed in sub A will not be captured. Have I got that right?
Attorney General.
So yes, that does give power to create exemptions through regulation, as the member suggested. And although at this stage, we don't contemplate any particular examples of what might be used for that power, what that power might be used for immediately, we were just thinking about ways that the Uniform Law Conference example and our example might give rise to that need under there. So one example might be for the family law enforcement provisions that are exempt. There may be times where there's accrued arrears where you would want to make it so they are subject to the enforcement provisions there. So these are hypothetical because they're not contemplated at this stage, but it gives the power to do such things if needed.
Member.
Thanks, Honorable Chair. I'll pursue it just a little bit because the regulatory power in both sub C and sub D relates to a prescribed class or type of order. So it very purposely, I understand the example the attorney gave, but that would be a specific case, and there might be circumstances in that specific case that a court would decide to issue, when we come to it a little bit later, an order suspending stay on the enforcement. But this is a whole class of types of judgments, and I remember confronted by when I a long time ago sat in that chair and would ask, or other chairs, and would say, if we're to my officials, if we're putting it in there, we must have something in mind. We must be thinking about something that might require, because what we're talking about is exempting this act from money judgments given by the Supreme Court of Canada, the Supreme Court of BC, Court of Appeal, Provincial Court, and a whole broad class. And I was trying to, the example the attorney gave is helpful, but it's an individual case. So if we take that example, it would be to exempt all maintenance arrears orders, and I don't think the attorney is contemplating that. At least I hope she's not, and I don't think she is. But ironically, it's in sub D. I would understand it's a more difficult question to answer because of the broad array of tribunals and administrative panels. But sub C speaks to orders of the courts. And I am curious to know, someone believed that there might be a need to exempt an entire class of decisions from those courts from the application of this act. And I'm going to press a little bit to just try to discover what was in someone's mind in deciding to include sub C.
Attorney General.
Okay, so the purpose of having these contained in here is really flexibility as the legislation comes into place and different regimes change. So for example, there might be contemplated in the future a separate legislative regime for collecting particular debts or assets in a certain way, in which case you would want the power to exempt certain things from this regime. The reason that the example that I brought before about the family maintenance or those kind of orders is there is a separate regime for that, right? That is set in place to help families collect on debts owed to them through the family justice process. And in some situations, you may want to contemplate having accrued arrears be enforceable through this process. And so the regulatory power gives the flexibility in the future to contemplate different ways that may be needed to collect.
Member.
All right, well, it's not the first time this conversation or observation's been made. In the scenario the attorney has described, it follows that there would need to be, if we're going to create an entirely different collection system for a specific class of money judgments, that will require legislative intervention. So at that point, it is hardly complicated to include the line in the bill that creates that new regime, notwithstanding the provisions of the Money Judgment Enforcement Act for the following purposes. So it's something that I suppose one can be critical of frequently, and that is, sure, the flexibility is fine, but the whole point of this, we are told, is to create a single means by which people can seek to collect their money judgments. And if someone is contemplating creating a different or alternative means, then that will require the legislature to consider that. It will, in many ways, defeat the purpose of what we're doing here. And rather than just use a regulatory process, I'm going to suggest it would be incumbent upon the government of the day to come before the House and say, we require your approval to defeat what was the intended purpose of this, which is to create a single means by which we collect money judgments. In any event, I have put that on the record, and I expect I don't expect that I will persuade anyone today about to go down a different path. I think that's, Madam Chair, those are the questions I had with respect to the definition, the definitions in Section 1.
Shall clause 1 pass? So ordered. Shall clause 2 pass? Member.
This is merely a question about, again, drafting techniques and how they may or may not have changed. So the purpose, and this is something that we discussed briefly a few moments ago about adopting the definitions of the Personal Property Securities Act. And in so doing, the exceptions to that are set out in sub A and B. A is pretty clear. The definitions apply unless the word or expression is defined in this act, or defined differently, I suppose. But then B, the context requires otherwise, which to a layperson says the PPSA definition applies unless it doesn't. So what? I'm not blaming the attorney. She didn't. I mean, she has to answer the questions about the drafting. But that's an interesting. That's an interesting turn of phrase that we're now utilizing. It seems. the definition applies unless the context requires otherwise. I'm not sure I know what that means, but I'm interested to learn.
Attorney General.
Okay, so as we discussed earlier on, we were talking about the contents and the process of this act. It's a very complicated piece of work, and it touches on multiple things, multiple types of property, multiple scenarios that might come up. So the provisions that I'm told that the member refers to in subsection B, it's a general principle of statutory interpretation that you give that ability in the legislation for a court to remedy a situation where there's an absurd outcome that is potential when you import the definitions from one act that's very complicated into another act. So it is a general principle of that statutory drafting to do that kind of thing, and that's the reason that it's in there.
Member,
I think I'm going to adopt that principle and use it with my wife in explaining my behavior. So, context requires otherwise. I think we're good to go to section 4, Madam Chair.
shall clause 2 pass? So ordered. Shall clause 3 pass? So ordered. Shall clause 4 pass? Member,
I should know this, but earlier on we defined court. In clause 4, court is lowercase. If it were uppercase, it would refer to the Supreme Court only, I think. In this case, does it apply? Well, I'll ask the question. In this case, in clause 4, which courts are we referring to?
Attorney General.
So court in this context is a defined term that's found in the definition, and it says unless context otherwise requires, it means the Supreme Court.
Member,
Right, so does this general principle that if I read it in that way, it would say the Supreme Court of British Columbia that grants a money judgment may make the following orders. Is that the intention, to restrict sub A and B to the Supreme Court of British Columbia?
Attorney General.
Okay, so as the definition says, of court, it has to be read in context, and because a court that grants a money judgment is in the context of that piece of legislation, it by those words applies to any court that has been granting a money judgment. They can make orders with relation to subsection A and B.
Member.
Thanks, Honorable Chair. I accept that's what the intention is. That's what I assume the intention was. But like the attorney, I immediately went to the defined term and said, oh, it is a defined term. So if the attorney, with the assistance of her able staff and officials, and somewhere on the other end of a line is the legislative drafter who assures us that the courts will interpret it that way, then I guess we'll take that and accept it. It is, I would suggest, a little bit confusing when you read it. It strikes me, just to editorialize, had it read any court, it would be clear that this particular provision relates to any court and not just the defined term. If someone listening believes that has merit, then perhaps the attorney will come back next day and offer up an amendment. The sub B, let's park the discussion about which court and assume that what we have here is something that applies to any court order that's issued. Sub B also empowers those courts to stay one or more enforcement proceedings indefinitely or for a specified period of time. Now, this gets a little bit complicated, because what I'm going to ask is, if you're a judgment creditor confronted by that portion of an order, is it appealable? Now, I think the superior courts have an inherent jurisdiction to do these things irrespective of whether the statute allows for it. I don't think the provincial court necessarily does, but this grants, if we're right, and this applies to all courts, this grants them that right. But if I'm a judgment creditor, I may not like that very much. And the provincial court also has some pretty strict rules about on what basis you can appeal an order of that court. So insofar as that power is being bestowed on all the courts that may grant a money judgment, is the decision or an order to stay enforcement proceedings, is that appealable by the judgment creditor in all of those cases?
Attorney General.
So the creditor in that instance would have the right of judicial review of that decision.
Member.
Thanks, Honorable Chair. And so in what circumstance? So we're now talking about, we've got various courts. We've agreed that we think we're dealing with various courts here. So in the case of, well, not an issue for the Supreme Court of Canada, not I suppose for the federal courts, but for the Supreme Court of British Columbia, is there a right of appeal to a stay order? And is it a right of appeal? And in the case of the provincial court, what the attorney has said is it's not a right of appeal. Well, it wouldn't be judicial review in the case of the provincial court. It would have to be an appeal right.
Attorney General.
Okay, so in the instance of a provincial court, that's under subsection B, a stay one or enforcement proceeding would be a judicial review, as I mentioned. In the instance of a Supreme Court, a BC decision, it would be an appeal.
Member.
In the case of the Supreme Court appeal to the Court of Appeal for a stay order from the Supreme Court of British Columbia, and in the case of a provincial court order staying I'm trying to, I want to make sure in the, let's just deal with the provincial court for a moment. I'm a judgment creditor because I have secured a judgment in the provincial court and presumably small claims court, it's provincial court. And I have initiated collection proceedings. The judgment debtor has gone back to the provincial court and asked for a stay order. Does the provincial court have the authority to order a stay? It seems that it would, by virtue of Section 4, it would have that authority now. And the attorney is saying my only remedy as a judgment creditor in that case would be to seek judicial review of that. And what is the test? What then would be the test in terms of seeking judicial review of that provincial court order? What's the threshold I have to meet? Is it different than an appeal, right?
Attorney General.
Okay, so important to start with the fact that this doesn't change, this act doesn't contemplate any changes in the regular procedures when it comes to your rights of appeal or judicial review under provincial court and superior court. It just relies upon them. So right now, under the Small Claims Act, it's a judicial review of a provincial order that would be like one contemplated under 4 subsection B. And the test for that is from the Supreme Court of Canada decision in 2011, justification, transparency, and intelligibility is the standard.
Member.
In the attorney's mind, what would justify an indefinite stay of enforcement proceedings for a money judgment? So I think we can all contemplate circumstances in which a court would say, for a variety of reasons, to a judgment creditor, and taking into account circumstances confronting a judgment debtor, look, you have secured your judgment for $10,000. You have that judgment. I am persuaded, however, that in these circumstances, I'm going to suspend the enforcement of that order for a period of time, given the following. But the section also empowers a court to suspend, to stay enforcement indefinitely. I thought the whole purpose of this was to say to a judgment creditor, you don't have to keep going back to court. Well, this requires them to go back to court, because now you've got a hollow judgment. You've got a judgment that is meaningless, because the court has said, fine, you won, you've spent all your time and money, you got your judgment, you're owed $10,000, but I'm suspending your ability to enforce that. And if you ever want to reacquire that, you have to come back to court.
Attorney General.
Okay, so just like anything in our justice system, we have to have trust in the courts and the decision maker in terms of determining the facts of the case and addressing and issuing the correct orders with respect to those facts. And there may be scenarios under that where actually issuing an indefinite order on a money judgment prevents the use of judicial resources or prolonged use of it if the court has determined that the money judgment order is in the context of a bigger dispute or a bigger issue in terms of, let's say, delivering on services or doing something, compelling a party to do something else, and that party is doing it, then maybe you don't need to enforce the money judgment order, and it's indefinitely, it's an indefinite order. I mean, this is all speculation in terms of where it may be used, but I just think that there may be times where the court sees fit to issue such an order indefinitely in the context of the facts that are before them.
Member.
Thanks, Honorable Chair. Look, I don't doubt that courts like to have the broadest possible discretion, and judges certainly do. And if we provide them with that discretion, then we should expect that they'll use it. I'm not sure we should be providing that breadth of discretion in this case. If someone has gone to the trouble, I mean, I am going to sort of remind the committee where this is applicable. Someone has gone to the trouble, has been obliged to go to a court, has litigated a matter, and had a trier of fact, an adjudicator say, ma'am, you're right. This person owes you X amount of money. And I certainly accept the proposition that there may be times and circumstances where the court would subsequently say, but here are some other factors pertaining to the debtor that I'm going to take into account. And look, this is always going to accrue to the advantage of the debtor. It is rarely in the creditors, judgment creditors, to their advantage to have their enforcement opportunity suspended or stayed. So the court says, I see some circumstances pertaining to the debtor, and I am going to temporarily suspend your ability, stay your ability to enforce that. I get that. That's fine. But to say to the creditor that has already, the judgment creditor who has already proven the case, has already demonstrated that they are owed the money, to empower the court to say, yeah, well, that's all well and good, but I'm suspending your ability to collect that for as long as I want. Well, I don't see how that is fair to someone who has proven their case. And it may be that the court wants to, the attorney says, well, there may be other circumstances at play. All of those circumstances would have been taken into account, circumstances about the debt owing would have been taken into account in the finding of fact that the debt is owing and the judgment is issued. And to now empower a court, and by the way, I am suspicious about how this might be used. Because sometimes creditors, judgment creditors, aren't always the nicest people. They might be right legally. They're not always the nicest people. So we create an instrument where a court can say, yeah, you know what, you're right, legally you're right, you're owed X amount of money and I'll make an order to that effect. By the way, I'm suspending your right to enforce it indefinitely. Yeah, I'm not sure that's fair. And I'm not sure it's necessary. Because the limited, you take out that word, and the court still has the right to suspend stay enforcement procedures, but it has to set a time limit and bring the parties back into court. But anyway, that's my submission. The attorney may want to respond, and I think it's probably my last question of the day.
Attorney General?
I'm going to suggest that we wrap up now, and I'll answer the question next time.
Expect me to remember what my.
Yeah, we remember, we will remember. Just given the time, Chair, I move that the committee rise, report progress, and ask to leave again, sit again.
Progress and seek leave to sit again. Those in favor indicate aye. Opposed? Motion is carried. Committee stands adjourned.